I think for any lawyer who argues cases, a good assisting counsel is something that you value dearly. You value because this is the person who's probably going to know the brief as well as you or better than you, but you value it also because this is your ally in the courtroom.
Mr. Jetmalani, in fact, I remember very well, told me once when I was trying to brief him at the last minute about some case law before he went into court, and he said, "Beta, you'll be there inside the court, so you can always tell me during the hearing. It's not as if I'm running away anywhere."
So I think that, assisting is quite an important art form. Often, the greatest solicitors, for instance, will bring much to the table, but apart from all that they bring to the table, they may actually also have a wonderful skill set, which many of the great solicitors have, which is aiding and arguing counsel. Reading a court, saying, well, don't say this, perhaps say that, I would leave this out, the judge doesn't seem with you, let's live to fight another day. That is what a good assisting counsel does, and it's an invaluable role.
So your job as an assisting counsel is actually to be the second set of eyes and ears for the senior counsel.
Presumably you have briefed the senior counsel who is going to argue this case. So you've done, I would say, 50% of your job.
Now, most important thing in that respect is a lot of issues do not arise in times of the briefing, but may arise in court because the judge is going to question you. So I think it's a very good idea, firstly, to be prepared much. Don't just think that if a briefing goes well, the matter ends there. Fresh issues will arise during arguments, and therefore if you have just thought through the problem, even beyond what the senior has asked you, thought of possible answers, possible questions which can be raised by the judges, and believe me, they will be very often asked by the judges. So it's good to just prepare about that in advance.
Then your job is, I would say, many things. One is actually being in the moment. I think a lot of younger lawyers don't quite appreciate that when you're assisting an older lawyer or a senior counsel, the game for you is still listening to the judge very carefully.
Keep an eye on the court.
Because often the person arguing has a lot else going on, is kind of focused on answering questions and may actually miss a question or two.
The judge is asking a question, there's something in the file which they want to say, there's X document which they want to read, which they're not able to get to, the opposing counsel is saying something else. And in all of this, it's almost like overstimulation, right? You're getting too much at once.
May actually miss mood and tenor, may actually sort of miss a point if he or she is reading from the brief, or judges are discussing, you want to stop this person and say, hold on a second.
So, for instance, it's really common that the judge is reading something, the senior is reading something else, they're not both on the same, literally they're not on the same page. You need to be able to stop the senior and to say, hold on, the judge is still reading.
You want to make sure that this counsel hits all the points that you have discussed in the conference before. Often things get left out. You want to also be acutely aware of the mood in the courtroom. And by that I mean the mood of the judge. By that I mean strategically, is this working out? Because in many ways, since you are not arguing the brief, you are not in the firing line. Therefore, you are actually under less pressure.
Your job is to be one step ahead of the senior in terms of what is the next document which they require, what is the next case which they require.
You need to be proactive in trying to keep documents ready for them if they're going to refer to them during the course of their arguments.
If they're making a certain argument and it's leading logically somewhere, to have those papers ready to be organized, that's one.
Also, just know your page numbers in and out. A lot of senior counsels will not necessarily be knowing the page numbers. Some of them noted it in extreme detail. They're very well aware of it themselves during the briefing, but others they know the matter broadly. They know, which are the important documents, but with page numbers, they are not very sure. And therefore, if you can just constantly be ready with it whenever they need it, it just makes the proceeding a lot more smooth. And the senior would really appreciate the fact that you're very thorough with the record.
What's important in assisting counsel in court is to strike the right balance between prompting them and not interfering too much with their arguments.
A good practice is not to get up on your own and speak out to the court directly.
So therefore, any interventions or prompting of the senior should be confined only to the most necessary points, number one. Number two, if the senior is missing a very critical facet or a fact or a proposition. Or number three, if the senior is not understanding what the judge is putting to him, and if the junior thinks he has understood and can explain to the senior.
Just instruct your senior, whoever that's, and he will then put it to the court depending on whether he considers it relevant or not.
Of course, there are instances when the seniors will regularly ask you in the middle of hearings as to what the next point is, and the lawyer has to be prepared for that. It's critical that the lawyer keeps his composure and does not become extremely excited and does not start arguing the matter himself, but lets the senior do his job and only intervenes as and when necessary to supply the necessary information.